Thank you, Mr. Chair, and thank you, witnesses and Auditor General. I like that opening statement. My opening round is for questions for Mr. Rami. In your previous capacity, primarily as VP of Investments, are the context of my questions in this round. The Fischerin Center, which is a center that Annette Fischerin set up at Cape Breton University, applied while Annette Fischerin was chair for, I believe, almost a total of $6.8 million through various SDTC funds, and that consideration came to the investment committee, I believe, which you oversaw. Is that correct?
Mr. Chair, this project was never approved or even considered by the Project Review Committee. The company had applied and routine due diligence was conducted, but upon being made aware that SDTC staff had conducted due diligence on this application, the PRC removed the project from any further consideration.
So on July 30th, 2021, you wrote in an email to your team, to someone named Jen, that you were fast-tracking the approval of that. What did that email mean?
Mr. Chair?
Jen, I think she was the applications lead.
That's correct. So this project applied via the standard application process. The fast-tracking you are referring to occurs when we have sufficient information regarding any application to move to the second step or the third step in our comprehensive six-step due diligence process. In this particular case, while I don't recall the exact details, if it was approved for fast track, that means it would have met that criteria. In general, in our process, probably about 10% of the projects that do apply would receive this fast track consideration.
So I appreciate that. Thank you. Did Ms. Fischerin call and inquire at any point of time onto the status of that application?
Mr. Chair, Ms. Fischerin never did ever call to inquire about that application.
On January 18th, 2022, you wrote that while the application would not proceed, that SDTC would give its best efforts to find the Fischerin Center money elsewhere in the government. Is that correct?
Mr. Chair, while I don't recall the exact nature of that email or recall that email, what I can say is it is common practice at SDTC where we will, if there is not a fit for funding within the SDTC programming, we have a variety of federal and provincial partnerships. And given the work that we would have done, for example, on an application and all the diligence, we do try and pass that off to other agencies, potentially where there might be a better fit. We don't try and influence those decisions. It's really more a question of can we convey what we have learned and pass that off for others for potential consideration.
So in essence, you act as a business development arm to find other government money for projects, including one named after the family of the chair of the board. On June 9th, 2022, a few months after that letter, the Fischerin Center got $2 million from the industry department. Then it got another $2.2 million from, I believe it was a COA, and then another $1 million from a COA. And it goes on and on over the next couple of months, $1.4 million from DFO, for a total of almost $10 million. So did your team help secure the ISED or a COA money in terms of directing them for the Fischerin Center when it couldn't get it from SDTC?
Mr. Chair, my recollection after would have been maybe after the initial round of introductions. I don't recall or remember us participating in any diligence by these other agencies. But to be fully, I'd have to look into to confirm that. But that is my recollection.
But you did commit, as you said was your standard practice, to help them, and then suddenly they, over the next couple of months, got shockingly money from the ISED department where SDTC reported to that minister, and also got money from ACOA, which also falls under the industry department. So I think actually it was a pretty good, in my view, bailout to get free business development, government granting money for an entity that was set up by the chair that then went and got money, actually more money than it was seeking from SDTC in the next few months from other departments. Did SDTC charge the Fisherin Center for any of those services?
Mr. Chair, as I previously just said, as a standard practice, we do try and engage in referrals to other agencies. It goes both ways. We also work actively, for example, with the Clean Growth Hub, and we receive many referrals from other funding programs. We offer this as a service for applicants in terms of trying to help them as much as we can with those particular referrals.
Thank you. That concludes.
Chair. Welcome back, Auditor General and your team. Always a pleasure to have you at committee. And thank you, Mr. Rami, for your attendance today. Largely my questions in this particular round will be directed to you, Mr. Rami. Prior to your attendance today, actually before I get to that, is this the first time that you've appeared at committee to discuss the SDTC?
That is correct.
Yes. So prior to your appearance today, did you receive any briefings from any other member at SDTC, the NRC, the Minister of ISED, any of his deputies or assistant deputies, or anyone in the Privy Council office or the PMO office?
Mr. Chair, I just want to clarify briefings. What type of briefings?
To prepare you for this hearing.
Thank you. Mr. Chair, I would have certainly have received briefings from my colleagues at SDTC. I would not have received any briefings whatsoever from, to go through the rest of your list, the NRC, anybody from the ministry, or did you say the deputy minister, or any other ISED officials?
Okay, so strictly from SDTC only?
That is correct.
Okay. In response to one of the questions put to you by my colleague, Mr. Perkins, in the first round, I saw you deliberately looking down and reading from what appears to be notes or a document. Is that accurate?
I do have notes that I prepared for myself.
Okay. We would like you to table those notes to this committee. Is that something that you'd be prepared to do?
I will look into that for you.
Chair?
Just one sec, please. Hold on a second. Mr. Brock, I'm going to let you continue, and I'm going to come back to you on that, please.
Were these notes prepared by you or any other member of SDTC?
Mr. Chair, these notes would have been prepared by my colleagues at SDTC, and I would have certainly had some input and contributed to that.
Who are the colleagues?
Mr. Chair, sorry, I'll have to, what's the question, sorry?
Who were the colleagues?
They were colleagues, the colleagues who've been monitoring the hearings that have been ongoing related to SDTC.
I'd like the names, sir. I would like the names and the official title of all those individuals who've been monitoring these hearings and giving you advice and or speaking notes in relation to your appearance today. Is that something that you'll comply with?
I will look into that, Mr. Chair.
You indicated in your opening statement part of your role as COO is to implement recommendations of the AG report. One of those recommendations of the AG report is to recover monies that were inappropriately taken from taxpayers. We have approximately $400 million identified as misuse taxpayer funds that went to Liberal insiders. A couple of months ago, we heard from one of the current acting directors, Cassie Doyle. I put to her several questions, as did other members put to her several questions as to when taxpayers will receive their money back, and she refused to give us a straight answer. It is something I know that the Auditor General is quite concerned about. When she testified back in June of this year, there was no clear indication from the government as to what the timetable was. So I'm asking you, sir, as the COO, what is the plan and what is the process, and when can Canadians expect to receive their hard-earned tax dollars back?
Mr. Chair, of the 11 Auditor General recommendations, 10 have been implemented. There is one that is ongoing related to a very specific recommendation around reviewing the eligibility of all projects that were covered in the sample period that was covered by the Auditor General in her team.
Sir, I'm not asking about the process. I'm asking about when will you answer a question, or a member of your team answer a question as to what the process is to repay the taxpayer. When can we expect this?
And Mr. Chair, just to continue, in that plan we tabled back in June, the eligibility review is targeted to be completed by the end of December.
Who's doing that review?
Mr. Brock, I'm afraid that is the time. We will certainly come back to you.
Thank you, Mr. Chair. Mr. Rami, on January 18th, 2022, you wrote to the Verscheren Center in which you stated that SDTC would, quote, give best efforts to help the Verscheren Center secure funding. The whistleblower stated in his testimony that unprecedented efforts were made by employees using SDTC's reputation to help secure funding for the Verscheren Center. And we know that not long after you indicated that SDTC would undertake its best efforts to assist, that the Verscheren Center received $10 million, or nearly $10 million in funding from ISED and COA. So how is it possible that you thought it was appropriate to use taxpayer-funded resources at SDTC to help secure funding for the chair's personal vanity project?
Mr. Chair, as I would have previously said, we do have a common practice for applicants who don't make it through our own process. We try and refer them to other funding programs, whether federal or provincial, and we try and assist in that referral process. I don't recall the specifics.
Yeah.
My recollection.
Well, sir,
is
with the greatest, Mr. Rami, I appreciate that there is a general practice or a general process, but this was not a normal application. It was an application from the Verscheren Center named in the name of the chair. It was her vanity project. She served as a director. Staff flagged the funding request for $6.8 million from SDTC to be in a conflict. So if that's a conflict, isn't it also a conflict, or gives rise to the perception of a conflict for SDTC to say, well, we can't fund you directly, but we're going to be the agent of the Verscheren Center to help secure funding from other government departments and agencies?
Mr. Chair, again, we assisted with referrals. Once those referrals were done, my recollection is we were no longer involved in any other application or diligence or whatever it may have been. The
whistleblower said that unprecedented efforts were taken to help secure funding, and that would be supported by the fact that you confirmed that SDTC did provide assistance, and then, just by coincidence, $10 million arrived at the Verscheren Center from none other than the Department of Industry, from none other than ACOA, which also SDTC, just by coincidence, falls under that department as well. So are you disputing what the whistleblower stated in his testimony?
Mr. Chair, just to repeat what I've said, we have a referral process. Once that referral is done, we're not involved in any of the decisions.
I don't understand, and I would like you to explain, because you wrote the letter, that if there's a conflict of interest to fund the project because it's the chair's vanity project, wouldn't the obvious thing to do to walk away entirely from the Verscheren Center, as opposed to saying we're going to take our best efforts and then direct staff to assist in helping secure funding to that project?
Again, Mr. Chair, to repeat my answer,
do you not see the conflict? Do you not see the perception of a conflict? I mean, this is an organization that is riddled with conflicts, so many conflicts that within hours of the Auditor General's report, the minister shut down SDTC. Do you not see the conflict or the perception of a conflict with what you wrote when you said, we're going to help you even though we're conflicted to actually fund you directly? We're going to do indirectly what we can't do directly?
Mr. Chair, our role wasn't to provide funding. We provided
but to act as an agent of Annette Verscheren's vanity project, after which she got $10 million from the very same department that SDTC fell under industry.
No, again, Mr. Chair, to repeat my answer, we weren't involved in the decision making at all. We wouldn't participate in that.
So you don't see a conflict. No wonder this is such a mess. It's all about helping insiders at SDTC will leave the room and get funding for a company. Well, we can't fund the chair's Accelerator directly, but we'll go around and we'll help them behind the scenes. And
Thank you,
it's really
Mr.
unacceptable.
Cooper. And to kick things off, Mr. Perkins, you have the floor for 5 minutes, please.
Thank you, Mr. Chair. This round, I'll be posing the questions to the Auditor General and your team, if that's okay. In your opening statement, you mentioned that the documents that you have in the government's production order, all documents that departments have. So, in essence, those departments can and should be turning those over as part of the production order. Is that correct?
We have documents from many different entities, but the bulk of what we have in our file is either from the Foundation or Innovation, Science and Economic Development Canada. And so, yes, the Parliament should be receiving government information from the government.
And most of those documents, as I understand it, there's over 10,000 pages that have been redacted, not complying with the order. And ISET is still going through the documents. They've done a couple rounds. I got others. But the order came, as I understand it, from reading the law clerk's letters. The order came from the Privy Council office to say to filter the responses through the Privacy Act and the Access to Information Act, which were not part of the House's order, which is why we're at the stalemate right now, where the government could produce the documents unredacted, because it didn't say redact them or filter them through these acts. They could provide it and get on with the stalemate. So could you tell me who in the Privy, as a recipient, your office as a recipient of that direction from the Privy Council office, who in the Privy Council office wrote that letter?
So I have received absolutely no direction from anyone at the Privy Council office. My desire to comply with the government security policy, which is a requirement of my act, means that I have to go to ISED and say, you own this information. How are you treating it? I think that this dispute between the government and Parliament is one where the government needs to answer for why it is refusing to hand over or redact information. As I used the analogy before, I'm a caboose on this bus. I need to sort of let them go first, then I need to asked them to help me treat the information they gave me in the same way, because it is their information that I'm handing over, not my information.
So they're communicating to you to redact documents in a way that was not part of the House order, I would assume, primarily through ISED and SDTC, who are both on the list from the law clerk as censoring the documents.
So they are not communicating to me. I have been trying to communicate with them to get assistance. As I mentioned, we've had about a dozen conversations. I don't know, Andrew, if you wanted to add more, but it's really up to them to tell us what they're doing to the documents.
Yes, since June, we've had about 12 conversations with ISED officials to figure out the protocol as to how to treat these documents. We will end up getting direction from ISED, but as you mentioned, that's going to be on the basis of the decisions that they have made on those documents.
Which ISED officials could you table the list with the committee?
So the main contact is the chief executive audit.
Pardon me?
The chief executive audit.
The chief audit.
The chief audit executive, sorry.
Chief audit for the department.
Yeah, for
Thank
the
you.
department.
You're aware that the Privacy Act, which was cited as a reason to exempt or redact these contract or these documents, Section 8 says that authorized bodies are exempted who have the power to redact documents, Section 8 of the Privacy Act. In fact, I think the Auditor General's Act has a similar provision. It says if you're an authorized body to order documents, has that power, they're exempted from the Privacy Act. Are you aware of that?
So I will give Andrew the option if he wants to jump in. So when I received a request from this committee to hand over additional information about the 90 cases of conflicts of interest, I actually had a conversation with the Privacy Commissioner about, I think it's 8.2M, the clause. It's in the Privacy Act. It is not in the Auditor General Act. And I explored with him what it meant, the will of Parliament, and then it is up to me as the head of the organization to weigh whether the will of Parliament supersedes an individual's right to privacy. That's basically what 8.2M is asking for. When I looked at most of the information I provided, it is information that you can provide, you can find in the public domain, and hence I provided that table to the committee and cited that letter. But I also felt it important
I'm just short on time.
to tell. I also felt it important to let everyone know that I was handing over that information.
In your opening statement, you acknowledged, as everyone does, the 400-plus year right of Parliament to ask for documents, and if they're unredacted, they're unredacted. That's a long-standing parliamentary right. Is it not true that this whole thing that has frozen the House is related to the fact that the government, the Liberal government, has chosen to ignore the order of the House, which was voted on by a majority of MPs representing a majority of Canadians? 3 parties, not just one party, voted for these documents.
Thank you, Mr. Perkins.
Is it not true they could avoid it by just releasing the documents?
I'll allow an answer to move on.
Yes, thank you very much. I think what you're bringing up is the nature of the dispute that's between the government and Parliament. We've characterized it as a dispute. Quite frankly, for us, we feel like we're in the middle of this, but it's really the government that should be accountable for the decisions to redact or refuse to provide documents.
Thank you very much. Mr.
Okay. Thank you, Chair. I didn't think I had to use some of my 5 minutes to educate some Liberal members on your particular role as an Auditor General. You're not criminal investigators. You've never been set up as a criminal investigator. So your ability to detect potential fraud or other acts of criminality in relation to what has transpired under the SDTC is not your mandate. Just like the Ethics Commissioner, if it's blatant, if there's an abundance of evidence, as you've indicated, you can make that referral. But the fact of the matter remains, despite the best efforts of Mr. Erskine Smith, the RCMP have confirmed an ongoing investigation. Whether or not they ask for a production order from your office remains to be seen. But the fact that they haven't doesn't necessarily mean that they won't. And I think that's the message that needs to come through to Canadians watching this. It is an ongoing investigation. They've also confirmed that they've received documents from the House of Commons in relation to the House order, but they've been heavily redacted, which is precisely why government and the House of Commons has come to this gridlock because of government's failure to produce all unredacted documents to the House, which can then be used by the RCMP as they see fit. Whether they look at it or not, that's entirely up to them. But in relation to the potential criminality here, Madam Auditor General, and I want to remind Canadians, we're talking about potential fraud and breach of trust. Fraud is defined in the Criminal Code under Section 380 as follows: everyone who by deceit, falsehood, or other fraudulent means, whether or not it is a false pretense, defrauds the public or any person of any property, money, or valuable security, is then guilty of an indictable offense, depending on the value. Redirecting taxpayer funds to the tune of almost $400 million outside of contribution agreements, outside of the law, is in its very nature a fraudulent act. Whether or not the Crown can produce and establish intent remains to be seen. But the police will investigate at a lower standard than the Crown prosecutor who prosecutes potential fraudulent actors in relation to this scam. Let's not forget that the Assistant Deputy Minister, Mr. McConaughey, equated this to simply giving away free money. It was the equivalent of a sponsorship-type scandal. That is how massive this scam, this fraud, this crisis, this issue that is now bogging down the government operations in the House. To ask you one final question, all of this could go away if the government simply complied with the order of the House and released all the documents pursuant to that order. Would you agree with that, Madam Auditor General?
I think, as I've previously said, this dispute between the government and Parliament is one they need to answer for and they need to resolve. I am, complying to the best of my abilities with the order, but ultimately the information resides and is owned by the government.
Simple. This is hypothetical. If the government continues to refuse to release the documents, we have continued deadlock. If the government complies with the order, we can get back to the business of doing government. It's a binary option. It's a binary choice. Would you agree with that? The options the government has: comply or not comply.
Again, I think that it's up to the government to answer for why they are redacting or treating the information the way they are.
Right. Okay. Now to Mr. Ramey. Have you been contacted by the RCMP?
Mr. Chair, I have not been contacted by the RCMP.
Has anyone at SDTC been contacted by the RCMP?
Mr. Chair, as far as I'm aware, no one at SDTC has been contacted by the RCMP.
How about the current board members?
Mr. Chair, as far as I'm aware, none of the current board members have been contacted by the RCMP.
Okay. And I think you've indicated this, Auditor General. I want to confirm again, you've had some conversations you've indicated with the RCMP, but they have not directly asked for anything specific. Is that correct? Or asked for any further interviews with you. Is that accurate?
You are correct. We do speak to them on many files, but on this file, we've had regular conversation and we have not received a production order.
Thank you. I'm afraid that is the time. Mr. Rock, Attorney.
And speak about our work, and I believe that is hugely important for our office to be able to support the Senate and the House of Commons.
Thank you very much. That is the time. Mr. Cooper, you have 5 minutes, please.
Thank you very much, Mr. Chair. To the Auditor General, Ms. Hogan, just for the record, to be clear, you're not a lawyer, police investigator, or an expert to determine whether there was a conspiracy to commit fraud or those types of matters, correct?
You're correct. I am a CPA.
Okay, thank you very much for that. And I would submit that further underscores why it's necessary for the government to turn over all of the documents to the RCMP instead of continuing to obstruct Parliament and instead of trying to use you as a shield to say, well, where was the criminal intent when you don't look at criminal intent, correct?
Our audit isn't designed to uncover intent or fraud. However, when we do find something that we believe might be potentially fraud or criminal in nature, we would refer that to law enforcement.
I'm going to turn my next set of questions to Mr. Rami. Mr. Rami, with respect to the seed funding stream, it's correct that in order to receive funding under that stream, an applicant needed an accelerator to nominate them, right?
Mr. Chair, in that process, we partnered with over, I believe, 80 accelerators from across the country.
No question that an accelerator
and
would need to nominate them, correct?
That is correct. And
okay.
We would open a round and accelerators would nominate.
So who at SDTC determined the roster of accelerators that would recommend projects under this funding stream?
That funding stream would have, it was our ecosystems team that ran that funding stream and would have reached out across the country to onboard accelerators.
Two of the accelerators that were on that accredited list were Mars and the Verschaeren Center, correct?
Mr. Chair, that is correct.
And we know that Annette Verschaeren sat on the board of both Mars and the Verschaeren Center. Did anyone raise any concerns about this, to your knowledge?
Mr. Chair, not to my knowledge.
So here we have a situation where there are two accelerators connected to Annette Verschaeren, and these accelerators get to hand-pick projects to be considered for seed funding that is approved by the SDTC board, the board that Ms. Verschaeren was the chair of, and it turns out that eligible expenses under the seed funding stream include the very services that these accelerators provide for a fee. That was the finding of the ethics commissioner in his report with respect to the Verschaeren Center. How was that allowed to happen?
Mr. Chair, the report of the ethics commissioner is very clear. I don't have anything to add to his conclusions.
It's a total racket, and again underscores the mismanagement and corruption and conflict at SDTC. To Ms. Hogan, is it correct that in your report you found that it was not assessed by the board or by the department whether the $38.5 million in COVID payments that went out the door complied with the contribution agreements?
The fact that the COVID payments were lumped together and in a bulk approval, I believe they were actually in the consent agenda item, which typically doesn't even have a discussion or conversation at a board meeting. That did not follow the requirements of the contribution agreement. The Parliament clearly laid out that funding should always be provided to an organization on a case-by-case decision, and that was not the case here.
We have $38.5 million that improperly went out the door. Mr. Rami, what steps have been taken by SDTC, the current interim board and interim executive team, to recover $38.5 million tax dollars that improperly went out the door?
Mr. Chair, as I said in the previous round of questioning, The board is currently reviewing all of the eligible projects, including these payments, and they will, as they go through that review process, will then take the appropriate actions as necessary, whether it's resuming funding, terminating funding.
$38.5 million
necessary
went
recovery
improperly out
funding.
the door, and your answer is that up until now, nothing has been done to recover those funds. That is $38.5 million. What about the $220,000 that went to Annette Verscharen's company in which she was found guilty by the ethics commissioner? I asked a month ago when 2 interim board members appeared here. They couldn't answer what steps had been taken to recover those monies. Has anything happened since, or has the board continued to be AWOL when it comes to making taxpayers whole?
Mr. Chair, that process is ongoing, and when the board of directors...
Thank you, Mr. Cooper. That is the time. I appreciate it.